Arun, I might want to borrow your mic. Welcome back, everyone. I think we might be disconnected. We're working? Is it working? Okay, very good. So, yeah, I think we need to stop this coffee break now. Just kidding. You don't want to miss this panel. So, we started the day identifying some of the key challenges, and we talked about AI, obviously. And as the AI revolution is taking shape, we know that the copyright law is being tested to the boundaries, right? And I'm really excited about this panel. It's a panel that brings together the legal, economic, and policy challenges at the center of this debate. From the training data to the fair use questions to the market impacts of AI-generated content, how do we balance the incentives for creators with the need to sustain the US technological leadership in AI? And I'm really excited because it's a great mix of, heavy hitter practitioners on the ground who are litigating these cases in the courtroom right now. We have leading academics from the law school and from business schools in this conversation, and from the creators' perspective, people who have been working with the creative industry for a long time. So I'm going to pass it on to Professor Arun Sundararajan from NYU, who's been working on AI for a while, to kickstart this panel and introduce all the panelists. Arun, thank you.
All right. Thank you, Kirti, for that, for sort of teeing us up. My name is Arun Sundararajan. I'm a professor at New York University, the Stern School of Business. I'm an economist. I also run one of our research centers focused on technology, business, and innovation. I've been deeply interested in this topic for many years now. I think there are sort of pretty unique challenges that are being posed to the idea of protecting, compensating, creating markets for not just training data, but for all published contents as the mode in which we consume content and gather information shifts away from being displayed content towards content that is synthesized by a generative AI system. So I'm going to start by introducing, I was telling the panel last week that this may be the easiest moderator job that we have today because there's so much talent on the panel. They're all conversational, and so I'm just going to sort of toss a couple of questions out there and then sit back and enjoy the debate. But I'll start by introducing the panelists, which I had advertised on LinkedIn as the all-star panel, and you'll see why. I'll introduce them alphabetically by last name. Actually, I'll introduce them alphabetically by first name because that ends up being the same, and I always favor alphabetically by first name given my name. My parents named me Arun because they thought that, it would put me sort of ahead of everybody else in these alphabetical things. Little did they realize that, I was going to take my dad's name and make it my last name. So our first panelist is Angela Dunning. She's a partner at Cleary Gottlieb. She's had over 25 years experience litigating copyright, trademark, trade secret, and other complex tech disputes. She represents, the world's leading tech companies on a wide variety of matters, including many of the high-profile AI copyright litigation cases, some of which we'll be talking about today. And she teaches trademark law at UC Berkeley School of Law, sort of widely recognized as a thought leader on AI and IP. So welcome, Angela. Our next panelist alphabetically is Annette Hurst, who is a partner and the global AI practice lead at Oric. She oversees a wide variety of their AI and IP work, which is often interdisciplinary. Annette is a sort of highly experienced trial lawyer who has tried copyright, trade secret, trademark, patent, and business tort cases of various kinds. From what I recall, the Barbie versus Bratz case was, one of her celebrated victories. Is a widely recognized authority on legal issues in AI and data use for machine learning, and consistently recognized as a top IP litigator in California. I believe recently was IP Lawyer of the Year for some of the work that she's done on the Microsoft sort of AI copyright stuff. So welcome, Annette. Kevin Madigan is Senior Vice President of Policy and Government Affairs at the Copyright Alliance. He is the former Deputy Director at the CPIP entity at George Mason, and has done a wide variety of extensive work across copyright and IP policy. He focuses on issues that include AI, of course, but also licensing, copyright enforcement, online piracy, which is not as actively discussed as a topic as it was 20 years ago, but it's still sort of really important and something of great interest.
It was today, this morning.
Okay. He's also a visual artist, musician, and registered copyright owner. So he does not just bring a sort of a policy wonks perspective to this, but a creator's perspective. So welcome, Kevin. And finally, again, alphabetically by both first and last name, we have Professor Robert Mergis, who's the Wilson Sonsini Goodrich and Rosari Professor of Law at UC Berkeley. And he's the co-director of the well-known Berkeley Center on Law and Technology. This is a center that he founded. He is widely recognized as one of the most influential scholars on intellectual property. He's the author of a number of leading books and case books on patent and IP law. His work is widely used in legal education and has frequently been cited by the US Supreme Court. So welcome, Rob. I'm also a professor, so I'm just going to call you Rob instead of Professor Merges. That's sort of like, I want to set the sort of, I want to set the culture so that like people call me Arun rather than trying to struggle with Professor Sundararajan. So. All right, so let's dive into it. We have a packed agenda. We will try and leave 10 minutes for questions. I don't know if we'll succeed, but we'll try. We're going to be discussing a range of issues from sort of taking a look at the current litigation landscape and what its implications are for the country. To looking at specific issues around training, around the provenance of data, around inference level issues that are coming up, questions around the copyrightability of AI output, questions around what the scope of protection of copyright should be in a world where increasingly the capability of a human to sort of stake claim on their creative process may be challenged by AI. So Kevin, I'm going to start with you. From what I understand, the Copyright Alliance actively tracks the cases associated with generative AI and the IP litigation landscape. So I know we have close to 100 active cases. We have about, 40, 50 minutes of this panel left. So I would implore you to be brief, but can you kick us off with sort of a really quick overview of what's going on here in the US?
Yeah, happy to, and thank you, Arun, and thank you to Kirti and Chris and everyone at CSIS for inviting me today. So as you mentioned, we're fast approaching 100 infringement cases filed by copyright owners against AI developers over the last few years, really since the launch of these popular generative AI models. And the lawsuits really started popping up in 2023. And forgive me, I'm going to read a couple things off this paper because I want to get the numbers right. So in 2023, I count 8 cases that were filed. That jumped to 13 in 2024. That more than doubled to 27 in 2025. And here we are, not even 3 months into 2026, and there's about 17 or 18 cases filed, which if that pace continues would put us at, I think, over 80 this year, tripling last year's count. So out of all those cases, about half are class actions, and almost all of those are by groups of authors of literary works against LLM, large language model developers. But there are also cases brought by visual artists, independent musicians, news publishers, YouTube video copyright owners, film studios, as well as computer programmers. The cases involve a variety of claims maybe most importantly, the direct copyright infringement claims that we'll get to the fair use issue that I'm sure we'll discuss in a little bit. But there's a whole host of claims, including contributory copyright infringement, which may be affected by the Supreme Court's decision this morning, DMCA violations related to the removal or alteration of copyright management information, as well as violation of anti-circumvention measures, and then a whole variety of state law claims like unfair competition and unjust enrichment that I don't think we will get into. The types of works in the case are literary works, musical compositions and song lyrics, sound recordings, computer code, photographs, TV and movie characters, videos, and databases. Just to give you a sense of where these cases are being filed, it's primarily in the Northern District of California and the Southern District of New York, as you may imagine. But there are a handful of cases in various other district courts in many different states. These cases are all in different stages procedurally because they've been filed over the last few years. But there's also been a lot of consolidation and centralization of the cases. So while there's been almost 100 filed, that's not really an accurate number for how many active cases there are, because there's at least one multi-district litigation that has, I think, over a dozen cases now underneath one judge. We have seen a lot of settlement activity recently, including the high-profile Bartz v. Anthropic settlement, as well as some record labels that recently settled with Suno and Udio and actually entered into partnerships with them. Just a couple other trends to mention, and I promise I'll wrap up, is we're seeing now lawsuits against AI companies that allege they engaged in infringement via downloading and sometimes simultaneously uploading using BitTorrent technology. And then there's also been a whole number of cases filed this year against AI companies by YouTube creators that claiming that the AI developers circumvented YouTube's technical protection measures to copy their works. But really what most of these cases are going to come down to is the fair use question over training. We've seen two pretty high-profile court cases last summer that tried to answer that question, but that's what, the main issue to watch moving forward.
Okay. And we'll get to those two high-profile cases. I'm guessing they're sort of the Kadri versus Meta case and the Anthropic case. I think they sort of tie into particular things. But before I move on, because I know Angela, you were the the lead attorney for Meta in Kadri versus Meta. But I have a question for you. But before that, my sense from sort of where things are is that there were early motions to dismiss. Then there were summary judgments, which sort of seems to be the current phase, which sort of create an evidentiary record that sort of one can draw from. And then there's sort of the the other court review, right? Like an appellate court review. I mean, is it where do you think we are in this process? And this is to anyone, do you think it's still early days and it's going to be the next 5 or 10 years, or do you think we've sort of hit a point where a lot of resolution is going to come in the next year or two?
I'm happy to take a crack at that to start. Let's see, is the mic working? So yes, a team of lawyers representing Meta was successful in obtaining summary judgment in the Kadri case, and we can circle back to that. But just this morning, the judge granted leave to amend the complaint to file a new complaint in that case. So just when you think you've made some progress toward resolution, then we're in some ways back to square one. We have a number of cases across the ecosystem that are making their way toward summary judgment this year on the core fair use question. And so we should see some more courts weighing in on that before long. But these cases are complicated. The technology is changing, and we have not yet seen an appeal with respect to the core copyright infringement or fair use decisions. And it's going to take some time, I think, for that to trickle up and get resolved at the appellate level. So if anyone is hoping that this is all going to become clear in the coming weeks, I think that is more optimistic than maybe the facts permit.
Okay. All right. So why don't we dive briefly into that particular case, Kadri versus Meta. Putting aside this morning's decision, I mean, in the decision that we're familiar with, what do you see as having been resolved, if anything, and what are the key things that were left open? And did they suggest any particular directions that you anticipate future litigation is going to take?
Yeah, so just building on the summary of the cases that are out there, I think it's important to distinguish between the class actions, which primarily are directed to the core training claim. Was it infringement to use works without permission to train a model? And those claims are going to turn on whether training is transformative and constitutes fair use. There are another host of cases, direct cases, not class actions, brought by large content owners where there are claims directed to outputs. And those claims have not yet reached the summary judgment stage and are taking longer. And those are going to be a very individualized assessment of the facts in those cases. But if you step back to the two summary judgment decisions that have been entered so far in the Bartz versus Anthropic and Kadri versus Meta cases, you have two judges, both from the Northern District of California, who concluded as a matter of law that training on copyrighted books without permission to train a large language model that is not accused of spitting out infringing outputs constitutes fair use. That this is spectacularly transformative. That's the first fair use factor. Is the use transformative? Does it serve a different purpose? And the courts both found that this did. It allows for the creation of a wide array of new non-infringing content. And both courts concluded, with respect to that core training question, that there was the plaintiffs had not shown any cognizable harm to the market for their works. In both cases, the plaintiffs asserted that the market for their works were harmed because they were deprived of the opportunity to license those works for AI training. And both courts held that there was no right under the Copyright Act to monopolize a transformative use of one's work. And so that theory of harm did not work for purposes of overcoming the fair use defense. There were a few important areas of deviation between the two cases. Judge Alsup in the Anthropic case distinguished between training on works and downloading works from what he called pirate websites for purposes of creating a general library that could be used for training or non-training purposes. And that was the claim he allowed to survive summary judgment and then ultimately granted class certification on, which led to a class-wide settlement that is still pending final approval. In the Kadri case, the plaintiffs argued that Meta's procuring of training data from these same sites precluded a fair use defense because it was done in bad faith. And we argued in the summary judgment briefing, and the court agreed, that the source of the training data didn't affect the analysis. The fact that somebody may have infringed that work in putting it on the internet does not change the fact that Meta's use was transformative and that plaintiffs could not show any harm to their own works or markets from the training use that Meta made. And so that was, I think, an important distinction in our case. So I'll stop there and let others chime in. But what remains to be cited, and we'll get into this, is some of the questions around torrenting and distribution. But the only two courts to decide this issue so far as a matter of law have decided that training on content constitutes fair use.
Okay, and there is this issue of, market impact that also came up, which we can come back to, which sort of had to do with, and, sort of to the best of my understanding, it was sort of opening the door for, the question of whether, whether an argument can be made relating to the ability that AI systems have to sort of create lots of content that might sort of impact the market of the data that they are trained on. I think a subtle, or maybe not so subtle point there is that, the counterfactual that you're going to be testing that against is, to what extent would the market have been flooded by the same AI system in the absence of the specific training data in question, rather than looking at the market impact of the sort of AI-generated content in isolation. And so that's sort of a very exacting counterfactual in some sense, sort of very exacting but-for world.
Yeah, I'll let others chime in on that too, but just very briefly to address your point. So in the Kadri summary judgment decision, our judge indicated that plaintiffs had failed to come forward with evidence to suggest that Meta's llama models were being used in a manner that was flooding the market and precluding readers from buying and finding plaintiffs' books, and that this could be, in certain highly factual circumstances, potentially cognizable harm under Factor 4. I think the problem with that, and Judge Chabria acknowledged this was a novel statement of the law, is that copyright law has always presupposed, when we're talking about comparing works, and on Factor 4, that the harm must arise from the fact that the accused work is usurping the market for the original by making the protected expression in the original work available to others. So somebody can now get the author's protected expression from the infringer instead of the author. But the theory of market flooding or market dilution that Judge Chabria sort of opened up questions about doesn't require that the content coming out actually be infringing at all. He expressed an openness to considering arguments that the fact that works being generated could compete with a copyrighted book, even if it's not infringing, even if it doesn't take anything but unprotectable facts and ideas, might be capable of demonstrating harm. Now that has not been validated in any case yet. It hasn't been put to the test with evidence. And Judge Alsup in the Anthropic case rejected that theory of potential harm. But this is another core area of deviation between the two cases, and one that will likely be sorted out in the decisions that are coming up now. Okay.
And and a point that you sort of highlighted, and I'll sort of pose this to Annette, but a distinction that was highlighted here was sort of a difference in the way that the two cases treated provenance. And so, this question of data provenance seems to be coming up frequently. So Annette, what do you see as the key issues here? Some of the questions that come to mind are, should there actually be legal significance to where the training data came from? Whether it came from sort of legally obtained material, or whether it came from some database that contained, potentially pirated works. And I guess I've also been thinking about, requirements for sort of traceability and attribution, and whether they make economic sense. Because we live in a world where, and I don't have a strong position one way or the other on this, but technologically it feels like the data pipelines that are feeding into, sort of the training data sets for these AI models, they're often billions of documents. They come from a wide variety of sources, dozens of jurisdictions. They're they pass through multiple intermediaries, and issues sort of copying like this came up. The copying issue came up 25 years ago in the context of how the internet works. And, they're filtered, they're deduplicated, they're transformed before they actually sort of enter the training process. And so, what scope is there, if any, for, questions of, requirements for traceability and attribution on the training front? I mean, and finally, there's sort of another question which I'll just sort of throw out there is, if the output of the model is indistinguishable, sort of depending on the provenance of the data, if it produces the same output, whether it was trained on, licensed data versus other data, should the law treat them differently?
Great, thank you. So I don't know how many of you are familiar with the technical aspects of this technology, and I don't want to repeat things that you likely already know, but I want to just give a few comments about what does it take to train a large language model in order to create a piece of general purpose technology. And the word that is used to describe this is tokens, because when you collect all this textual data and it's processed into a form that can be used to train a neural network, it's processed into a form called tokens. And they're a little bit less than a word, all right? So if you think of a token, you could think of it as a word. It's probably a little bit less than a word, but that's the number. And the current state of the technology is that it takes more than 10 trillion tokens to train one of these models. Okay, so the volume of data that it takes to train successfully a large language model is so enormous that it's the entire internet plus, right? It's the entire internet many times over. It's warehouses full of books. And it's nothing that any single author or publisher could ever deliver. And so that makes a very strong case for fair use, because that's a market failure situation. You need all this content from everybody. If you give anybody the right to hold you up on the data, everybody has the right to hold you up on the data. The transactional costs of negotiating that make it impossible. And to Arun's point, there's no way to attribute value in the operation of the model to any particular one or group of those tokens, okay? So this is a paradigmatic case for fair use, but the judges in California struggled with the idea that it was okay to go get that data, book data, from what the plaintiff's lawyers call a pirate website. Right? And you can see why judges would struggle with that, because historically the copyright law would be strongly against the existence of these websites, and publishers can go and get injunctions to shut them down and take them down. So should that make any difference in the question of whether it's fair use or not? Well, of course, Angela was successful in arguing that it shouldn't. And even though it's a little bit counterintuitive and uncomfortable for us, that is the right answer. And the reason is because this is already something that people are doing without authorization. And so if you give an authorization right based solely on the provenance of the data, you've completely eviscerated the concept of fair use. Another way of thinking about it is, especially since we're in an international setting, is that we don't have a general attribution right in the copyright law in the United States. And one of the important reasons we don't have an attribution right in the copyright law in the United States is that fair use reflects the principles underlying the First Amendment, and the idea that we don't want even individual authors to be able to control how their expression is used and disseminated once it's been published, right? And it's different in other countries. In France, the droit moral, the moral right, gives authors a right to control their publications from the perspective of their moral or ethical values. But in the US, we have always viewed copyright as an economic incentive to greater expression and not some aspect of a moral right. And so I don't think there's much of a role for attribution here under traditional US principles. And I think if we want to keep having free commentary, free criticism, parity, and all the other paradigmatic fair uses, then this actually does fit for those reasons right into that category.
Okay, thank you for that. That's very instructive. Any reactions from anybody? Because I was going to move to Rob and just sort of talk about licensing, but
Yeah, just a quick, before we wrap up the cadre conversation, I don't disagree with anything Angela said, but the decision was a little more nuanced. I mean, I think Judge Chavery was very clear that his hands were tied to a certain extent because of the record presented in the case and the failure of the lawyers to procedurally present the case. And I just wrote down this one quote of his. He said, excuse me. He said, "As should now be clear, this ruling does not stand for the proposition that Meta's use of copyrighted materials to train its language models is lawful. It stands only for the proposition that these plaintiffs made the wrong arguments and failed to develop a record in support of the right one." So I just bring that up to say that, you know, when we're talking about the impact of something like cadre, I think it is limited, and you know, it just goes to show, like, the fact that fair use is such a fact-specific analysis, and so many of these cases involve different types of models, different types of work at issues, different types of facts. I just don't know how wide the impact of that is going to be.
okay.
Okay, so we have over 100 cases filed by various creative people, photographers and writers and painters. We have a strike in LA by people whose business, their whole work is entertainment. They create entertainment products. And these people are all saying this technology is having a major impact on us. And yet what we hear is there's no harm. There's no harm. There's no harm that counts, right? To quote Judge Alsop. None of these harms count under copyright law. So I'm a patent person, and that's when I teach copyright, I can maybe not get caught up in quite the details that I do in patent law. I won't bore you with non-obviousness type double patenting, but it's similar to some of the arguments that we get shaving the fair use factors. I take a step back and say, there's all these creative people who are saying this is having a major impact on us, on me, on my future. And yet copyright law tells us there's no harm, right? Now I know copyright is a narrow instrument. Nothing that these guys have said, the litigators, doctrinally is wrong. It's absolutely the proper statement of current fair use law. I think that transformative use has basically swallowed fair use. The concept of transformative use is not in the statute. It's a law review article from 1990. I wish I'd written it. They also have talked about the fact that we just really need to focus on this spectacular transformativeness. If we had maybe a more thorough and robust case law, if transformative use hadn't sort of taken over fair use, then we might have a little more consideration like what we got in the Warhol case, which is we start from the proposition that creative people should be able to license their works. The ability to make a living from professional creativity is not irrelevant to copyright law, okay? It should be the core of copyright law. And what we see, starting with the Betamax case and starting in the file sharing wars, is that there's become this sort of conflict between individual copyright owners and new technologies, in that the copyright owners are cast as barriers and obstacles to new technologies. And we're Americans. I teach patent law, right? Being a Luddite is sort of the worst thing you can say about an American. We're the future, you know, we're optimistic. We believe in new solutions, ingenuity. That's sort of our calling card. So when you get cast as the opponent of new technologies, you're on the defensive. And when you have simple taglines that you have to sort of fight, information wants to be free, patents kill, things like that, you're also on the defensive, because the anti-IP story is an easy story. The pro-IP story is complicated. It requires a lot of complexity and transactions and all the stuff that slows down the technologists, right? I've got lots of friends in the AI field, and I know that if you're a grad student and you're trying to get your thesis done, stuff like subject approval and copyright is just a barrier. That's the way you're trained to think. But out here in the real world, real creative people are being impacted by this. Now look, in an ideal world, if you look at the complexity of these arguments, if you look at how much the future is going to be affected, this isn't really an issue that belongs in court, right? A court case, putting aside class actions, is plaintiff A versus defendant B. And it is meant to be an extremely microscopic inquiry into the rights and duties of A and B. That is a terrible vehicle for making long-term policy that's going to affect a lot of people. Look, it's the one we have. It's the only one that's working, so we use it. The companies are basically saying, we're happy to come into court and defend the construction of our AI models. This is the chosen forum that society has given them. No beef with that, none at all. It's just that the voices that are trying to be heard about the future can't be funneled through this tiny little pinhole called litigation. There are thousands of creative people who are worried about this technology and who think, with this much creativity at work in the world, these fabulous LLM models that do really cool stuff, why can't we be more creative about structuring transactions and structuring licensing markets that would give me a little bit of money, right? Is that such a horrible thing? Is that really so contrary to copyright law that we might want to help authors and creators? Is that really now extraneous? It's not a harm that counts. It doesn't count. For creative people, what they hear when they read that is, you don't count. You don't count. Okay. And let's face it, artistic creativity is being rolled up into these huge capital systems. Individual creators, individual laborers, individual workers are just being replaced by giant platforms. Does that sound like a future we want to encourage? I'm not sure.
I'm sort of like, I feel like, we've reached a turning point in this panel where, the rest of the panel will either be a debate of this point.
We're over here with our hands. We're just back.
Or we will move on to other things.
So pile on it, like we just come.
Yeah, so I'm gonna reject the clear expressed opinion of the panel, which is to respond to this and move on to the next topic, and maybe we can come back to it during Q&A. And so I'm, like the world that we've been talking about sort of like, over the last, 30 minutes or so has largely focused on training and copyright. Like, does training infringe copyright, or is it fair use? There's a separate issue that Rob brought up, which is like, is there a compensation model? Maybe we can get to that if we have time. This is, whenever I say that to my daughter, she's like, that means that we're not going to get to it, right? I mean, like, she's like, sort of ask me later kind of thing. I mean, but Annette, I'm going to ask you about a different front in this sort of, in this AI world that has opened up quite dramatically over the last year. And this has to do with inference time retrieval. And I'll, models are trained on data, but what you get out of ChatGPT or Claude or Gemini today is often not just coming out of the model based on its prior training. At the moment that you enter the prompt, a wide variety of other information is also retrieved, put into the context window of the system. This is a highly simplified view of it. And in real time, like used to generate the response that you see. So these could be news articles, they could be other things off the internet, they could be from private databases, but this is the distinction between training and inference time. Like at the moment that the prompt is entered, new information is pulled, put into the context window, and used to try and sort of generate the output. And so the, Annette, I mean, I guess my question for you is, like, there are a number of cases now that are questioning the use of this sort of like, content at inference time through what are called RAG systems. And so these are, think of a RAG system as a system that does this, pulls the data and sort of puts it into the context window to allow the LLM to come up with a more grounded answer. And so do we sort of get into like, public display territory rather than transformative use territory when this is being done? I'm asking you this because of, sort of your work with Microsoft and sort of your recognized leadership there, and Microsoft trying to set up a publisher's content marketplace to potentially compensate publishers for this kind of use. Like, is that going to be the answer, or is this going to be settled through, sort of the narrow pinhole, as Rob put it, of litigation? Yeah.
Yeah, good question. So I do represent Microsoft in the New York Times versus Microsoft case, and I'm its lead copyright lawyer in a wide variety of areas. Having said that, I should say I'm just speaking here today as myself and Ed Hurst, and the opinions that I offer are my own, and they're informed by 35 years of big case copyright litigation, including big cases in which I've represented the plaintiff, like Oracle and Oracle versus Google. So I think on this other aspect of the technology, so we talked about training a minute ago, that's how you get the model. Then once the model's in operation and you ask it a question, it can go retrieve additional data. This is called retrieval augmented generation, or RAG, the acronym that Arun used, and present that information to you in a summary form. I think there are a number of salutary benefits of that, but probably a lot of you have heard about hallucinations when it comes to generative AI, which is you can ask it a question and it gives you a totally made up answer, and that answer can be wrong, right? And one of the benefits of this RAG technology is that it helps eliminate hallucinations and try to improve the performance of these models from the perspective of consistently delivering accurate information. And you can imagine why that's important in a wide variety of contexts. And I don't think anybody would question that this particular technology was a fair use in the context of enterprise implementations where people are using the models against their own data. So really the question is there something different about these general purpose search tools, chatbots, Copilot, Gemini, the others that are, evolutions of search engines? Does this fit in the traditional search model where there's an exchange of value between offering a copy of a snippet in traditional search terms or a summary of an output in next generation search terms with a link that you can click? And maybe it does depend on whether there is something that is verbatim displayed or not, because we know there is a traditional market for verbatim displays, and that traditional market has been the subject of licensing. That doesn't necessarily cover the use of the content in summarizing and delivering factual information, though, because facts are not covered by copyright. And there's a long line of cases saying that if what you're doing is copying to get at facts or ideas, that's an intermediate copy, it's still a fair use. So, of course, Microsoft is innovating because it's historically licensed content from all these publishers, part of MSNBC, now MS Now. Its search has presented answers. It is trying to do this on a consent basis, and it does that with its meta tags also. And so, you see developing more of a consent and value exchange model in this particular context, but it does also depend on whether the technology is delivering copies in the outputs versus simply summarizing factual information as part of that generation.
Okay, yes.
Could I add just one thing? So also speaking just for myself and not my clients, and thanks for the proviso, Annette. That thing that Annette just said about facts and ideas not being protectable is super important, right? Nobody has the right to monopolize facts, even concepts or theories that somebody originates for themselves. We are seeing deals around making display of other people's content in the context of AI. That is something that we are seeing. we are also seeing deals arise to obtain access to content that would not otherwise be available, accompanied by a whole host of services, including curation, metadata for that data, reps and warranties about its provenance, indemnification provisions, right? Where people have been able to go out and collect vast swaths of data that they can clean and curate and provide a whole host of services around to enable that content to be easily used for training. There are certainly deals that are being entered with respect to that kind of service. And they contain service level agreements about the amount of data that has to be provided on a daily basis so that it is timely and useful for grounding. What we haven't really seen, because there is this market failure point that Annette had pointed to, are deals for use in simply training a model. And in part, that's because there really isn't anybody that has rights to offer that for training across a vast swath of data so far. We also haven't seen in any of the cases yet any of the authors or musicians or other content creators coming forward and actually pointing to a loss of a sale or a loss of a licensing opportunity due to the training or use of these models. So that hasn't come out in evidence yet. I think, to Rob's point, there are certainly people who are worried about that, and those views are, I think, genuinely expressed. But in the cases so far, we haven't seen any evidence, for instance, that this author can no longer sell their book because it may have been trained on by a variety of developers to create a general purpose AI model. And so I think that that's an important point as well.
Okay, and you know, I'm going to be like incredibly ambitious for the next, 7 or 8 minutes that we have, and try and cover the copyrightability of AI-generated works, the scope of copyright, and finally, sort of whether we are entering a phase where we are de facto going to be, as a country, sort of held hostage by the legislation in other countries rather than our own, which, so I implore brevity. But Angela, it seems natural to start with you on sort of the copyrightability of AI output, since you're known for sort of winning a case that established that a monkey cannot hold copyright, even when it has a cute name like Naruto. This was like the monkey selfie case like 15 years ago. And so, I mean, at this point, we're dealing with a different issue, which is less about whether AI can hold copyright, which is also a separate issue. I mean, but more about whether, what is the status of works that are generated by AI or, assisted by AI. And I don't know, what are your thoughts here? Because, I feel like we're entering a world in which sort of the lines between human and machine-generated content are blurring. They've certainly blurred in the assignments that students submit to me. Or maybe they haven't blurred. They are very clearly sometimes generated by a machine. But, there's it becomes hard, right? I mean, like when I write email, a machine is helping me write the email. And, as these machines sort of permeate the process of creation by humans, where do we land on, the status of machine-generated works?
Yeah, so it's long been accepted in the US, and the monkey selfie case only validated this, that human authorship is required for copyrightability and registration. But what human authorship means is being determined now. So we had an early test case in which an inventor attempted to get copyright registration for a work that he described as being entirely and autonomously created by his AI model that he had developed. That was rejected for copyright protection, and it has gone all the way up now to the Supreme Court, which rejected his petition for certiorari. He stated in his application there was no human authorship, and without that, no copyright was afforded. we have a more nuanced case in which an artist who won an award for a work that he had created using the Midjourney tool was denied copyright registration. He has brought an action in the district court in Colorado seeking to have that determination overturned by the courts, which will have the final word. And that is pending. The summary judgment papers are fully in. The Copyright Office has maintained that registration was properly denied because he didn't control the output of the model enough. And he has argued that that isn't the right standard, that he is the human author who deployed a tool in service of the creation of a work that would not otherwise exist, that he put in substantial effort, which has never been the standard for protection, but substantial effort, and he guided the expressive choices that yielded that output. He chose the color, the lighting, the imagery, and he worked at it until it was substantially modified from what the model had initially output. And his position is that that constitutes the human authorship necessary to warrant protection. And we should soon get a ruling on that. For my own personal view, I think that there has to be a way that human artists and creators can deploy these tools in service of their craft in a way that still allows them to own those and monetize that work. We don't want to give protection to everyone who enters "give me a cat," wearing a scarf into any AI model, but where there is a meaningful contribution of human creativity, then I think that we are seeing some path to potential for registration. The Copyright Office has, in fact, registered many works that used AI in their creation, and I'll mention just two more points. One is a film that was recently protected. You've got copyright protection for the script. You've got copyright protection for the human animated content. And the fact that AI was used in part in creating some of the scenes or characters doesn't overall change the fact that that work is protected and cannot be infringed or used by others without consent outside of fair use. And then the Copyright Office has registered a work called a single slice of American cheese. It's an image that was generated entirely using an AI model and a process called inpainting, where the author placed each part of the work. Each part was AI generated, but the author placed each part in the work. And so the overall composition, although entirely AI generated, was human directed and therefore entitled to copyright protection. So I think we're going to see people continue to experiment with how they can use these tools in a manner that they are controlling and in a manner that they can document their human authorship for the office. And as I talk to studios and developers and independent creators, the conversation is definitely shifting to not is that going to replace me, but how can I use that and protect my own work?
Okay. And sort of an extreme way in which you might imagine someone using generative AI in their creative process, which I'm I'm skillfully using this as a transition to our next topic, is the idea of training a generative AI system to produce exactly like you, sort of like giving it all your works and, through reinforcement learning, making it your twin, and then sort of claiming ownership over its output, even if the output did not involve you sort of playing a role in creating it because you've created your AI twin. And I'm not a lawyer, so I don't know where this would sit, but I guess the broader...
Rob is going to hire you to write his final exam hypotheticals now.
But this may well be... this may already be happening, sort of unbeknownst to us, right? I mean, but to me, it's part of a broader question around, like, what is the circle around sort of the protectability of a human's creative process? And Rob, I'll turn to you on this because copyright has sort of always, largely at least in sort of my my non-lawyer view, sort of had a fixed core. I know that there are exceptions, like, the work itself. but there is pressure from the perimeter on sort of a wide variety of fronts. There's the case Anderson versus Stability AI on whether artistic style is protectable trade dress. There are right to publicity claims that sort of cover voice and exposure. And, you know, that they're starting in likeness, and they're starting to, you know, in some people's views, look like sort of copyright light. There's the moral rights argument. So, you know, do you see the circle of ownership for authors sort of from copyright and sort of the surrounding bodies of law growing or shrinking? And, you know, I guess is litigation sort of filling a vacuum that Congress hasn't addressed?
Yeah, I'll try to be quick. I think that a lot of these issues will come up, but not here in the U.S. I think we know that overseas jurisdictions, you know, protect moral rights, they protect style in different ways, and I think the test cases will come from those jurisdictions. And so the answer to your question will turn on copyright plus these other forms of protection. One that might get some traction here would be trade dress, but that depends on consumer reaction. If consumers believe that a certain style is associated with a certain artist, it could be Motherwell, it could be Warhol, it could be Miyazaki style, Studio Ghibli style. Trade dress might protect the duplication of that because of confusion as to source, the confusion that this must be authorized by Studio Ghibli because it looks just like Princess Mononoke or Porco Rosso or one of his films. And but that has to be tested in the market. That has to do with consumer reaction. It's possible that if everyone duplicates style all the time, that there'll be a lot of dilution and then nobody will think that anything comes from anybody in particular anymore. That's got to be tested empirically in the market. So I say overseas jurisdictions and then experience with consumer reaction will tell us how broad those other theories can go.
Okay, and Annette and then Angela. I mean, Annette, I'm going to ask you because like in that sort of like MGA Mattel case, I mean, this was sort of a test of substantial similarity, and that's one dimension of the scope of copyright. I mean, where do you see things going? And then Angela, I know you have some thoughts as well.
Well, I think the problem with letting trademark law substitute for copyright law here is that there's no limits on trademark law. It can last forever. And, you know, copyright does expire. I mean, it's a long period of time now, so whether that's wholly relevant is probably debatable. But there are fewer limits on trademark, and, you know, this concept of, you know, confusing similarity has not really ever been part of the copyright law. So if we think we had good reasons for limiting copyright law not to include ideas, and methods and other things that are defined in 102B as outside the scope of copyright, then letting trademark take up the banner for copyright will violate that historical set of limitations, which are not just fair use, but ideas and other things as well. And the Supreme Court in the past, when confronted with that issue, has said no. In the Daystar case, where basically they tried to take, Lone Ranger had come into the public domain, and then somebody tried to turn it into a trademark, and the court said no. Now Disney's testing that with Steamboat Willie, right, trying to turn it into a trademark. So, you know.
So I'm defending Midjourney in the Anderson case, which is the only case that I'm aware of in the country in which this trade dress claim has been asserted. And I think it's important to consider the repercussions if plaintiffs were to be able to establish protectable trade dress in art styles. In our case, one of the plaintiffs describes their trade dress protected art style as simple, cartoony, and often strictly in black and white. that describes the style of just about every cartoonist there is, and something that this person could not possibly have originated or exclusively used. But the implication of affording individual artists the right to control and monopolize a style means that all other artists can no longer build on those art styles. That does away with art movements, right? It means that one cannot potentially create in the Cubist style that potentially Pablo Picasso originated, or maybe he didn't, right? Maybe that was built on something someone else did. But in the US, we've always, the purpose of copyright law is to promote the creation of new expression, affording trade dress protection for something as amorphous as art style, which would be a concept not protected by copyright law, I think serves to potentially harm the very artists who are pursuing these claims, because it would box them in and significantly restrict their ability to innovate and create and build on what came before.
Okay. I mean, this is such a rich and varied area with so many, I hope that we've sort of given the audience a sense for the spectrum of issues that are coming up, sort of at the intersection of artificial intelligence and intellectual property. I'll end with a sort of a question about legislation and sort of what that means for the United States. And I throw it open to all of you, but maybe start with Kevin. But there's a fair amount of consequential copyright policy making that's taking place outside of Washington. There's Japan, which sort of as far back as 2019 was taking a very permissive stance on AI training data. There's the EU pushing for transparency and opt-in. There's Singapore carving out particular exceptions. And so I worry that overseas legislators are sort of becoming the sort of de facto legislators for our tech sector, where a lot of the innovation comes from. And I often draw a parallel with GDPR and sort of it became a global standard in some sense. And, what do you guys think? I mean, are other countries sort of setting the standards that our global AI companies have to build around? And is the absence of a timely American legislative response, is it actually sort of ceding that ground, or will the litigation end up being more influential than any overseas legislation?
Yeah, I would say, we certainly have been slow to legislate compared to some other countries, but I also would say that I don't think any other countries have sort of figured everything out yet. We're seeing different approaches in different areas, but we're also seeing massive pendulum swings back from places like in the UK, where a year ago they were ready to implement this, TDM exception and opt-out regime, and now it's a complete 180 from where they were a year ago. And I think one of the reasons that we're, a little more slow to legislate is because we do want the courts to figure things out, and because we have a very specific U.S. fair use style. And I also would just note, we've talked about licensing a little bit. I think by holding back a little bit on legislating, we're letting the free market do what it does, and we're letting AI companies and copyright owners come together and enter in more and more deals every day. I think, Meta entered in a deal with the news publishers last week. And so to me, that's what we should all want, is sort of a win-win, where the AI companies and copyright owners can thrive together, and that will ensure sort of our national dominance in AI.
Okay. Kirti, can we borrow 5 or 10 minutes from the coffee break for 5? So let's borrow 5 questions and see if there are questions from the audience. Yes, sir.
Just one question. Are these new technologies asking all of the people that we have to accept that there are 2 kinds of art? The art of that guy that suffers all his life to make this great work of literature, and then this engineer that just got some combination of many, many things and creates this new thing, which is a combination of all this data. Then are we asking now that this is just a new form of art. But then the second question is, what is the cost of these models? That they require lots of water, energy, and many other things. Do we, society, have that duty to pay all those costs so that those guys in the big companies are able to make these models?
Okay, well, that's a deep question. I will.
I think I can combine an answer to that with my rebuttal to Rob. There are so many areas of this technology that need regulation. And I'm going to just make my pitch that copyright is not one of them. Historically, the courts have worked out the question of fair use. But courts cannot work out international arms treaties about the use of AI in war. They cannot work out whether we're going to start standing up nuclear power plants to fuel data centers and what that's going to do to our existing power distribution system. They cannot work out what happens when deep fakes are used in elections. All of this stuff cries out for immediate regulation. And the companies want the regulation because the regulation levels the competitive playing field when they know what the rules of the road are. Frankly, copyright is the last issue, and historically has been one that it is almost impossible for Congress to come to quick agreement on. The 1976 Act took 40 years, right? Because of the competing economic incentives. So for particularly this audience, it is important to think. There's a massive amount of fear among creators. There's a massive amount of fear among coders and knowledge workers, right? Because this technology will have profound economic impact. That's something that should be addressed by legislation and regulation. Copyright is the least of the problem.
Okay, well, fair enough. I mean, I think that there's at least a dozen different governance issues that sort of are aside from IP that, so can we borrow the next hour and have a panel about all the other AI safety issues? Maybe we can take one more question and then we'll break for coffee. Anyone has one? Or do you need coffee to come up with your question? Is that the state that we're in? All right, well, thank you so much. Really interesting, learned a lot, yeah. Thank you. Yeah, this was.
finish dot on time because right after us.
We'll be sure.
Yeah, no, I'm just letting everybody know. We have to finish dot on time because right after us is I'm gonna start talking so that we can have people start rolling back in, rolling back in. Calling 1, 2. It's working. Okay, good afternoon, everyone. We're gonna start here because we'll have a break soon. So this panel, as you know, is about streaming era. So, for a decade, the smartphone wars dominated our headlines and our dockets. But as we sit here now in 2026, the battleground has shifted. So it starts with this technology called video compression. You all use videos. They need to be compressed and decompressed to be transmitted, billions of bits per second. And they use these technologies called advanced video codecs or high efficiency video codecs and so on, which are technology standards. And they have now become critical for $8 trillion economy. Today, all streaming platforms and devices use video coding standards. And as the industry has evolved, so has the licensing landscape. And we're in the middle of some global litigation for technology standards right now in streaming. And there are other alternatives that are, offered for what some have claimed royalty-free licensing terms. So there are new questions at the intersection of IP and antitrust. So with that, I'm very happy to introduce this panel, which brings a very nice mix from all different perspectives. We have Dina Kalai, who is a Deputy Assistant Attorney General at Department of Justice Antitrust Division for International Policy and Appellate, with a long tenure in industry and in former government positions. Thank you for being here, Dina. We have next to me Steve Jedlinski, who is a general counsel at Siswell, former big law partner, and I note, a fellow engineer turned to the dark side like me. And then we have Kyle Mack over there by Dina. He is a partner at Sullivan and Cromwell's Antitrust Group, named, I want to just say that to embarrass you, Kyle, one of the top antitrust lawyers by the Daily Journal. Former deputy director at the FTC's Bureau of Competition. So we have a great roundup here, and we can talk about different perspectives. Kyle, I'll quickly start with you with the where. We're seeing global litigation from Eastern District of Texas to the courts in Europe, UK, even Chinese courts, trying to set global FRAND rates. What's the current state of play in global litigation right now? And what are your clients and their adversaries using as strategies?
Well, I mean, the bottom line, as most folks will know, is that when it comes to high-stakes IP, FRAND, and related antitrust claims, we're really in the middle of one of the biggest surges of those types of litigations that we've seen in a very long time. I'm a competition person, not a patent person, but you don't have to be a patent person to see the way this is unfolding, and it's unfolding worldwide with Germany, the UK, the UPC being some of the principal jurisdictions with major work and major litigation unfolding, but Brazil, China, India, all in the mix. On the US side, we're seeing all the same FRAND, IP, contract, other issues being litigated, but we're also seeing Sherman Act claims increasingly being used, particularly by the implementers, as a means to try to balance some of the litigation risk unfolding as these disputes proceed. As far as the tools go, it's not a mystery that from the innovator's perspective, the principal tool for an innovator trying to negotiate a FRAND license or other form of license is going to be the threat of an injunction if you have an implementer that doesn't take a license. So most of what the implementers are doing is to try to find a way to balance on the litigation side, is to try to find a way to balance the risk of that injunction. That may mean an anti-suit injunction, asking a court to issue an order trying to prevent a party from seeking injunctions in other places. It may mean a short-term or interim license that makes it more difficult for the party to try to seek an injunction in another place. But the principal thing is to try to get more runway in order to negotiate or not negotiate, in some instance, the license that the innovator thinks the implementer needs to take. On the US side, of course, we also have the Sherman Act claims, where generally speaking, those claims involve some allegation of misconduct, a good claim or not, of some type of misconduct before the standard setting body, but there are different formulations in which that's laid out.
Thank you, Kyle. So, Steve, can I turn to you for a second? So, Kyle sees these disputes when they boil over, but you're in the trenches trying to strike licensing deals. As a patent pool, you deal with both licensees and licensors, so you see, how this, if pools are being effective in sort of handling or streamlining the licensing complexity. Can you give us a sense of reality on the ground? What's working, what's not, what are the friction points?
Yeah, so I think bottom line is, patent pools work, and it's actually at the back end of a lot of these litigations that you see patent pools are the clearinghouse for these litigants or these defendants who are faced with injunctions. And we've seen it time and time again. And pools really only work if they can find a common ground and there's a deal to be had. And there's only a deal to be had when there's buy-in from both sides. And pools are unique where, it's a combination of the patent owners with an administrator like CSIS, and then trying to do a deal with a licensee, and really trying to find that common ground and something that works. And in my experience, I think the things that work is transparent pools. And what does that mean? Independent essentiality checks, published terms, patent lists available, and information that licensees know exactly what they're entering into in the conversations.
So what's the problem, Steve?
Yeah. So what's the problem with respect in particular on the video codec side of things is what we've seen is there's a long history of video codecs being in the marketplace and being licensed. They were often licensed at the device side of things. And now there's a whole new target with the advancements in technology over that time frame where, I just saw it last night when I was in my hotel room. I went in, opened my phone, opened a streaming app, was able to cast it to my television and watch it in 4K without any sort of buffering or anything else, something my kids have no understanding is a specialty, but something that certainly has changed in a very short period of time. And so what we're now seeing in the press is a lot of conversations or a lot of litigations, some of which were filed by patent owners in this room against the content streamers who are having a hard time understanding that things have changed and the landscape has changed. And so now I think it's a matter of trying to find the right framework. And there is a number of pools out there. And I think over time, those pools will adapt and function to the marketplace needs and find that common ground, which will be the ability to find those licenses.
Thank you. That's the thing. There are many licensors, many pools right now in this technology now, unlike the past. So Dina, this was all a tee up towards a speech that we are all waiting from you to hear. So DOJ has been incredibly active lately, right? The division has filed statements of interest in several cases, and they're related to remedies available for SEPs and what factors need to be assessed for determining whether standard essential patents confer market power. So let's turn the floor to you to give your perspective. And I know you've been in the industry, you've worked in the government. What's the regulatory framework that governs the entire ecosystem? Thank you, Dina.
Thanks very much, Kirti, and thank you for having me here today. I do have prepared written remarks, and they're also going to be posted on our website later today. If anybody needs them, if members of the media want to see them, and if they're not posted yet, I've given a few hard copies to Chris there in the back, so he can give you a copy. And for that reason, I'll give a shortened version, and won't read the full speech, but I highly commend our website, where it will be posted hopefully in the next hour or so. Yeah. So America is the land of innovators and entrepreneurs. And as President Trump has recognized, our economy is the greatest in the world because we, more than any other country, incentivize individuals to dream big, take risks, and make the impossible possible. Our country embraces innovation and entrepreneurship, and that commitment has helped make our economy the greatest economy in the world. Now, a robust intellectual property regime plays a big role in promoting innovation and competition. As President Trump proclaimed on World Intellectual Property Day last year, the future of our great nation depends on the continued safeguarding of our intellectual property, which fuels economic growth, technological progress, and global competitiveness. Today, I'd like to highlight several work streams we at the Antitrust Division have worked on to usher in what President Trump has called the golden age of American innovation. These matters all involve principles that we believe are key to sound analysis of dynamic innovation scenarios. So the first work stream relates to ensuring that proper market power analysis applies to intellectual property. There's now a well-established recognition that in the US, antitrust laws apply to conduct involving patents as they do to other types of conduct. Our 2017 DOJ FTC antitrust IP licensing guidelines reaffirmed that the antitrust agencies apply the same analysis to conduct involving IP as to conduct involving other forms of property, while taking into account the specific characteristics of a particular property right. So antitrust laws are designed to take account of different product and market characteristics and circumstances, and the analysis with respect to IP is not fundamentally different than in other contexts. Similarly, in the IP context, as in other contexts, US antitrust law do not provide a basis for challenging high prices that are not the result of independent anti-competitive conduct. But there is nuance in exactly how standard antitrust analysis like market power map onto the IP context. And that nuance is extremely important because market power is often a threshold question in antitrust analysis. A long time ago, patents were viewed as not only conferring exclusive rights to the product or process, but also, therefore, as conferring monopoly power in a relevant market upon their owner. Modern antitrust enforcers and courts reject such a simplistic view. Our antitrust IP guidelines that date back to the original 1995 version clearly set out that the antitrust agencies do not presume that a patent confers market power. The US Supreme Court has later endorsed this position in the Illinois Tool case. So rather, applying basic antitrust analysis, the existence of market power depends on the assessment of other factors, including whether there are actual or potential close substitutes for the patent. If there are such substitutes, that would constrain market power and any exercise of it. Recently, the Antitrust Division further clarified this principle in the context of standard essential patents in the Disney versus InterDigital matter in the Delaware District Court, and that was a video codec litigation. In our statement of interest in this matter, the division explained that, as is the rule for all patents, there's no presumption of market power simply because a patent has been incorporated into a standard. But the analysis does not end there. As the division statement of interest outlines, whether a standard essential patent owner has market power depends on an assessment of various factors. First, it depends on whether there are alternatives to the standard. Just as products compete against each other, different standards also compete against each other. If the standard has substitutes, then incorporation into the standard may not confer market power. Second, what are the contractual obligations and commitments that the patent holder may have voluntarily undertaken pursuant to the policies of the standard development organization that created the standard? If a patent holder has pledged that it will license its patents on FRAND or RAND terms, then those commitments could protect against exercise of potential market power that could have been conferred by SEP status. In Disney versus InterDigital, there were allegations in the complaint that the patent holder, InterDigital, had undertaken numerous commitments, including promising to license the patents on RAND terms. And there are no allegations regarding the potential alternative technologies. So under those circumstances, antitrust demands additional analysis. Establishing market power cannot depend on a presumption based on incorporation into a standard. Relying on such a presumption would be an incorrect application of the antitrust laws that creates an unwarranted assumption of market power. It may also unduly reduce incentives for innovators to contribute to cutting-edge technology that goes into industry standards. Notably, this clarification with respect to analysis of market power conferred by standard essential patents is consistent with the long-time position of the European Commission, whose horizontal cooperation guidelines explain that, as a quote, there is no presumption that holding or exercising intellectual property rights essential to a standard equates to the possession or exercise of market power. Rather, the question of market power can only be assessed on a case-by-case basis. So that's the quote of the European guidelines position. The second topic I'd like to address is protecting the right to seek relief from courts or other adjudicatory bodies when disputes involving IP rights arise. And I'll address both access to courts and access to adjudicatory bodies like the ITC. First, as many of you know, there is an antitrust exemption called the Noer-Pennington Doctrine, under which seeking judicial redress is protected from antitrust liability. Drawn from the First Amendment freedom of speech principles, the Noer-Pennington Doctrine exempts parties petitioning the government from antitrust liability, even where such activity may be considered anti-competitive. As the Supreme Court has recognized, the doctrine extends to the right of access to courts, which is one aspect of the right to petition government. Thus, going to a court and exercising a right to seek judicial redress cannot serve as a basis for antitrust claim, absent application of a sham litigation exception, in the patent context, an assertion that a patent has been obtained by fraud, known as a Walker process claim. As the Antitrust Division's statement of interest in Disney versus InterDigital explains, in the IP context, patent holders, including SEP holders, should not face antitrust scrutiny and the possibility of treble damages for seeking redress in the courts. Patents are property rights, and the only way to enforce them is through litigation. Enforcing those rights seeking relief for patent infringement in court is generally a protected exercise that cannot give rise to antitrust liability. Otherwise, potential antitrust liability could reduce innovators' incentives to invest in innovation and participate in pro-competitive standard development activities. Striking the right balance requires protecting the ability of patent holders to seek relief without risking antitrust liability. Second, protecting the ability to seek redress for patent infringement is not limited to the courts, but also extends to adjudicatory bodies like the ITC. Under Section 337 of the Tariff Act of 1930, if the ITC finds a violation, it shall issue an exclusion order barring the importation of infringing articles except where extraordinary circumstances justify altering the relief. This framework is vital as a way for patent holders to protect their IP rights against foreign imitations and be able to block the flow of infringing products into the United States. Last November, the Antitrust Division, in partnership with our colleague from the U.S. Patent and Trademark Office, filed a joint comment on the public interest in an ITC proceeding filed by Netlist against Samsung. The joint comment explains that the public interest is not served by transforming the public interest factors in the statute into barriers to enforcement. Consistent with the statutory design, the determination of public interest should follow the findings on infringement and validity, not precede them. Undertaking a public interest assessment on the front end before hearing the case threatens to make the public interest a threshold determination, creating another procedural hurdle for patent enforcement. As the joint comment explains, the infringement claim is the antecedent question. To allow the public interest aspect to serve as a gatekeeper function would contravene Congress's intent and encroach on the First Amendment right to petition government and seek redress. To protect American innovation and make sure U.S. patent holders are able to seek relief for infringing products coming from abroad, we must maintain a system of robust enforcement of valid patent rights. This begins with protecting access to avenues through which patent holders can seek redress. Finally, I note that protecting patent holders' rights to seek redress in courts is similarly recognized on the other side of the Atlantic, where the European Court of Justice, in the Huawei ZTE matter, has clarified that European law provides for a range of legal remedies aimed at ensuring a high level of protection for intellectual property rights, including the right to access to a tribunal, although that recognition is not recognized as a complete exemption there. So to conclude, the division's recent work in this area has clarified that analysis of any market power conferred by patents, including standard essential patents, should always be undertaken on a case-by-case basis. Furthermore, we've clarified that patent holders who seek redress for patent infringement are generally exempt from antitrust liability. And we believe that these clarifications are important for supporting American leadership in cutting-edge technologies. We at the division plan to stay vigilant about these issues and to continue to work closely with our colleagues at the USPTO to advance our shared goals of promoting a strong and effective patent system that is key for competition, consumers, businesses, and our economy. Thanks.
Right, thank you, Dina. So look, I mean, it's important to have that framework in mind, and I want to turn to some of the hot button issues that sit at the intersection of IP and antitrust on this right now. So I'll turn back to Steve on the topic of licensing negotiation groups. So platforms where multiple companies, like for example, car makers or tier 1 module makers can collectively negotiate licenses with patent owners. And this is quite relevant right now. The European Commission has blessed these kind of licensing negotiation groups for automakers, and as of Monday, very recently, we saw that the DOJ opened an investigation on exactly these. So we already know that, Dina, you can't comment on this. So we'll, just want to put two things on the table, right? Like on the one hand, the licensing negotiation groups have proposed that, look, this makes it easy for us to reduce the transaction costs where small implementers can't negotiate on a one-on-one basis. It's too costly for them. On the other hand, obviously, the competition concern is if this is basically a buyer's cartel. Now, you need to make licenses happen. So from your perspective, are you finding these LNGs as a potential one-stop shop on the licensee sides more or less efficient?
So, I mean, I think it's way too early to necessarily say whether or not they're more or less efficient. But I do think the risks and the concerns are very real. I know there's been a lot of conversation about, an argument from one side that, an LNG or licensing negotiation group is just the flip side of a pool. And I think that's just fundamentally wrong. And it goes back to kind of what the focus and the goals are of each of these entities. And I really think from the pool standpoint, again, our business is trying to get deals done, and we live and die by market acceptance, and market acceptance is license agreements. And whenever there's alternatives, we're always open to those alternatives and are willing to pivot and listen. But the concern, and we just haven't, with respect to LNGs, is all it seems like is, like it's alluded to, it's a buyer's cartel. There's lack of information in terms of how it's going to be structured and how it's going to work and how the different members within that LNG would necessarily operate and how it would actually lead to a frictionless deal. I'm not saying there isn't a scenario where a handful of SMEs, it might be applicable. Again, it's highly factual. But generally speaking, from what we've seen, it's primarily our concern is that it be used as a holdout mechanism. Because what is an LNG? It's a collaboration between competitors, and oftentimes, or what we see now today, is some of the largest competitors in a very defined market, and their goal is to get a royalty rate. And I don't think that royalty rate is necessarily a rate that's going to cause them pain. It's going to be a rate to set the lowest rate possible for that largest market. And I think the biggest fundamental difference is that they are already using that technology, that they are actively making products and devices in the marketplace, and their only goal there would be to delay. And what does that delay buy them? It buys them less damages in court. It buys them expiration of patents. And so I think the concern is very real about these LNGs simply being a buyer's cartel with a secondary purpose of holdout.
So can I challenge you a little bit? Because you're operating a pool, CSIS, and the argument has always been for the pools is that they reduce transaction costs. You bring together licensors. And what we always hear is that, well, the same thing applies for licensees. They need to reduce their transaction costs too, and they need a one-stop shop. So why is that? Why are you, what is your argument for saying that pools on the one hand are efficient and licensing negotiation groups on the other hand are not?
Yeah, so I think as an initial matter, pools are really, putting together a set of complementary patents from a bunch of different patent owners, where an LNG is putting together a bunch of competitors in a room. And I think that's, again, a fundamental difference. In terms of reducing transaction costs, I think the question is, and it hasn't been articulated to us, and we have been approached by an LNG, and these questions have been asked to them in terms of how is this group going to be set up? And it seems it doesn't have the transparency, it doesn't have the insight into how it's actually going to allow and become this frictionless world where licenses would end up. And so I think those are the realities of what we're seeing. And then, finally, obviously, pools are well regulated and established and have a long history. And in contrary here, we have a very new and market power dominant group of parties trying to negotiate on the other side. And so, I think that's the reality that we live in right now.
Kyle, Dina, anything to add on this one?
I've said enough of this topic. I'm going to sit this one out.
He's the expert.
Okay, so Kyle, Dina mentioned the Noor-Pennington doctrine, and is that a doctrine that you think will be further refined in the upcoming cases? Or let me ask you this, what are the other significant legal issues do you see as the most prominent now from a litigator's perspective?
Well, focusing on competition issues and really bringing a litigator's perspective to this, which is to say, thinking about how the cases are won or lost and how they're resolved in a reasonably efficient way, which may be a lot to expect from the way that we do this sometimes. To me, the key issues are where substance and process start to overlap. So a good example of this is a question of how courts are going, what courts are going to demand from a plaintiff when it comes to the substance of a complaint alleging anti-competitive conduct in something like standard setting. We have in the antitrust world this enormous body of case law that tells us how much a plaintiff needs to say if they're bringing a monopolization claim or if they're bringing a price fixing claim. And the bottom line is, it is not enough for a plaintiff to come in and say, competitors A, B, and C got together and fixed prices. The courts, by and large, say that will not survive a motion to dismiss. You need to put a lot more meat on the bone to get over the feasibility standard that the court laid out for us in the Twombly and Iqbal cases. But when it comes to alleged misconduct in standard setting or something of that nature, we don't have nearly as much law that helps answer the question about how much a plaintiff needs to be able to say. And it becomes a very important question because it could be the gate between a complaint that gets dismissed and one that gets to discovery. And I think there's a real question of why a complaint raising something like that should be subject to any lesser standard than what we would apply when we allege some other type of antitrust misconduct, like price fixing or other type of antitrust misconduct. So that will be very interesting to watch, and I think it will be pretty aggressively litigated. The other one that Dina touched on are questions of market definition and market power. This is one where the antitrust case law historically has gone the other way. It's actually historically very difficult to get an antitrust complaint dismissed on the basis that the market definition as pleaded is not sufficient. But that is changing across the board in antitrust, and more and more and more courts are asking the question when they look at market definition, does this really make any sense given what we know from the face of the complaint? And my personal view is that we need to apply the same lens when we look at these types of IP and antitrust cases. And as Dina touched on, we need to ask, does the complaint consider what the alternatives are to the patent, what the alternatives are to the standard, and how does that change the plausibility of the complaint? This is all an area that will be developed more in the coming years, I think. Now, you asked about Noor-Pennington, and fortunately, this is an area where I think the legal standards are pretty clear. It is very difficult. There are exceptions, which Dina touched on, but it is, generally speaking, it is very difficult to to bring a claim under the antitrust laws that's predicated on some sort of petitioning to the government, courts or otherwise. My personal view is that's totally appropriate. This is a constitutional right that parties are exercising. And the case law is pretty clear that those claims are hard to bring, but we are seeing complaints that start to blend together litigation conduct and other types of petitioning conduct with other forms of conduct that aren't protected by North Pennington. And I think, and I hope that we will see the courts make a pretty clear statement that petitioning is petitioning. It is protected regardless of how clever and how sophisticated the plaintiffs are in trying to blend that together with other things that are alleged to be anti-competitive, because it is, at the end of the day, a fundamental civil right that we have to seek redress. And North Pennington doctrine is, notwithstanding the complicated name, it is not an obscure corner of the antitrust laws. It is the First Amendment. So I hope that the courts will continue to make that standard quite clear.
Dina?
Yeah, maybe I'll compliment some of the comments you made. I agree with you, and I think that's the reason I'm not aware of any U.S. case. There's a lot of noise, but any court decision that found it seeking a remedy for infringement is an antitrust violation. People continue to make it, but the fact that no court has ever agreed with them, I think, is telling. The other point I wanted to point out, I would never make fun of my current employment, so I'll speak about my prior agency, the FTC. So in the past 30 years or so, the FTC has brought a line of standard development cases or cases that try to allege that a FRAND or RAND violation is a violation of the Sherman Act or even of the Section 5 of the FTC Act. Started in 1995, I think, the Dell case. Then there's many years of the Rambus litigation. Then there was an NData, which was a settlement. Then there was Google MMI, and then there was the Qualcomm case. So we're looking at 2.5 decades of cases that are in this space. And as far as I can tell, never has the FTC won in court on any of these cases. Some of them settled, but that's not a binding precedent, right? The parties chose to settle with the FTC. But there has not, and the ones that they litigated all the way to the end, the agency lost them. So I'm just starting to think that maybe there are better avenues to spend agency time on, because U.S. law has not endorsed these theories in its decisions.
So actually, I wanted to ask this question to all of you, and maybe we can start with Steve and go around. What's similar and what's different from what we saw and learned from in the smartphone era, when we had, so much licensing and litigation and these regulatory battles around, wireless cellular and mobile and smartphones, and now that what we are seeing in streaming? What's different and what's similar?
So, to me, it actually seems to be a pretty simple answer there. Is what is similar is, multiple pools, a bunch of different avenues to try to get the different rights that are necessary to practice the standardized technology. All of those same issues were around and present during the cell phone wars. And now what's different with streaming is, the biggest difference is the different implementer that's being focused with those challengers. And they're new to the market in terms of having to license these standard essential patents and having to learn what goes into it. And I think that's the biggest difference. It's the same issues that have been facing other parties in the past, but a new party facing it.
So I'm not from this industry. I would say from an antitrust perspective, it seems to be a replay of the same movie, pun intended if we're talking about video codecs. It's again, simply those who are using the technology are throwing antitrust, I think, weak antitrust arguments in an attempt to reduce or not to pay royalties, but the analysis from the antitrust side is the same.
Well, I would say, first of all, this scale and significance of the issues is absolutely extraordinary. I mean, everybody in the room probably has 2 or 3 different potentially streaming devices with them at this moment, which is phenomenal. But from the litigator's perspective, I agree. The antitrust issues are fundamentally similar. What's different this time around compared to what we were doing a couple of decades ago is we know some of the basic principles that the courts will apply. They may not be the same circuit to circuit, but we know some of the basic antitrust principles that the courts will apply. And now we're figuring out the details of how we will actually litigate this and how it will actually be done in the details. And that gives a litigator a lot of tools to work with because of the areas of the law that have not been developed in terms of how we actually, what we demand of a plaintiff, what the standards of proof are going to be, and the actual refinement that we've had in most other areas of antitrust law historically. And so that's the space from the litigator's perspective that we're going to see a lot of refinement.
Yeah, maybe I'll add, there's more guidance from the agencies too, right? Both from the first Trump administration and from this Trump administration. And then in the courts, we had Apple Motorola from 2014, right, in the federal circuit, which progressed the law on this topic.
Yeah, and I guess as I sit here more, thinking about it more, is we have a lot more jurisdictions at play. I mean, we have Brazil, we have India, we have the UK, which some folks in this room are well versed in. So I think that the new jurisdictions and the new challenges or the new issues in each of those is probably another major difference between now and the past.
Yeah, that's true. The landscape is far more global. We really started with that in the morning with Andre's panel, and makes it just that much more complex. But are you finding, because you have this 20 years of history and a toolbox, are you finding it easier this time around to navigate this licensing landscape, Steve, from a pool's perspective?
Yeah, I mean, I think, as Kyle alluded to, I think one of the challenges is that you have large implementers that are being faced with these licensing demands that, while the per unit demands themselves aren't necessarily big, but it leads to massive dollars that you're talking about. And what happens when there are massive dollars at play is global litigations. So
let me ask you one more question, and I want to move to a different topic. There has been, you're working on the licensing, Kyle's working on the litigation, and we're watching the movie from here, and it seems like these disputes have begun, but it might really just be the beginning. Do you see it that way? Do you see this wave coming? Or do you feel like we are near sort of this resolution from the industry?
Yeah, I think this is the beginning. I mean, I think the daily alerts that I'm seeing about new litigation, which means there haven't been the licenses taken, seems to be at an uptick with new names every day. And so I think we are, where we're at in that curve, I don't know, but it is increasing. But I can foresee the end, as I do think a lot of the pools out there that have licensing offers in these spaces will be the one that will be approached to say, hey, I'm going to take a license from you because you're going to be the best resolution at the end of the day. But it's going to be how many years down the road that is the question.
I don't know, because I'm not from industry, but I would point out that's a job security for Kyle here.
I'm totally comfortable with this. Look, this is not the only space in which I work, and the things that we see as litigators is that where there is a lot at stake, you will have disputes because it's worth pursuing it. So there will become a point where the parties have enough clarity from the courts, or they are boxed in enough from the way the litigations have proceeded that everyone gets reasonable and starts to resolve this stuff, and we move on. We've seen that in other industries. I'm sure that will occur. But for now, there is a lot at stake, and I think we'll continue to see a lot of disputes. And
meanwhile, this is raging globally.
Yes.
So Dina, let me switch topics, actually. So I wanted to ask you about this. So we are staying now on the topic of video coding technology. And I'm sorry, because, we are talking about the streaming platforms, and one thing that I wanted to note is it's possible that this sort of licensing activity is beginning with video coding as a standards technology. it may move into other kinds of technologies. That's one thing maybe, Steve, you want to give your perspective on. I'll stick to my question, though, on video coding for a minute now. So, Dina, I would like to ask you about this recently formed Alliance for Open Media. It's, I guess in the words of standards, we will call it a consortia. And it's a bunch of companies that came together. They're creating a a competing standard to existing video coding standards called AV1. And so it's competing against these sort of the most commonly used video coding standards today that we've been talking about that are currently being, licensed, and we're seeing the litigation battles on. And they're saying that, look, we are coming up with these competing standards and they're royalty-free. So are they royalty-free, and what are the competition concerns that you are seeing from a regulatory perspective?
Sure. So one step back, right? In general, the antitrust enforcement community tolerates standard development, among other things, thanks to the FRAND or RAND kind of safety valve that ensures that there's no exercise of market power. So I guess one concern that may exist with respect to these consortia is whether indeed they have a FRAND-based PAN policy that solves the potential problem of exercising market power. And when there is no FRAND available, that's when perhaps we, antitrust enforcers, are a little more skeptical with our tolerance of collaborative/collusionary standard development. Another issue that is possible with consortia is that unlike traditional, air quotes, right, but traditional standard development, they're not subject to all these safeguards that we have in the SDO Advancement Act of 2004, right? The openness, transparency, balance of interests, consensus, etc. So I would say that in order to develop a standard, and it doesn't matter if it's in an SDO or in a consortia, and stay clear of antitrust scrutiny, you have to make sure that it was developed in a way that adheres to these safeguards, procedural safeguards, and that RAND or FRAND is available. And these are areas that could be perhaps challenging in consortia like the one you mentioned.
Steve, you want to say something here?
Yeah, I mean, I have a slightly different focus than what Dina was talking about is, while there's arguments or statements being made that these are royalty-free standards, for example, CSIS runs a pool related to one of these where it has a bunch of patent owners that have patents that read on that standard that is alleged to be royalty-free. And it's taken a lot of education and explanation to get to a point where, CSIS has now successfully licensed a number of those parties under that standard. But it took a fair amount of effort because of this rhetoric out there that the standard is free. But that standard was built on inventions and technologies of patent owners who were not part of that consortia and didn't agree with that rhetoric.
So can you unpack for us, what does it mean then that these, what does royalty-free tagline mean here then?
I think it's the antithesis of royalty-free. I think there are many patent owners that are not part of that consortia that believe they contributed to the R&D loop, that inventive loop, and committed to their IP rights. And believe they need their licensing revenue associated with it. And I think with respect to the parties in the consortia, how they're justifying their royalty-free analysis is a bit questionable to me as well.
So Kyle, more coming towards you soon, I think. I think we can take some questions from the floor and engage a little bit. Go ahead.
Thank you very much for this very interesting discussion. My name is Ute Schneider, I'm from Avanci. And Dina, if I may, I was wondering, since you started with explaining how market power in an SEP context has to be analyzed on a case-by-case basis, I was wondering because in in conjunction with the debate around so-called licensing negotiation groups, there has always been, or often is, there's often an argument made that an LNG would confer countervailing market power on the participants of the licensing negotiation group when they are to negotiate with the patent pool, for example. I was wondering what your views on that specific arguments might be.
Sure, I think Steve kind of already answered that, right? So in a pool, by definition, for the pool to pass antitrust scrutiny, the patents in a pool have to be complementary and not compete between them. By contrast, my understanding is that in a so-called licensing negotiation group, the members are direct competitors, which means that they're substitutes. So it doesn't sort of, there's a false premise in the question.
Anybody else? Steve, you want to do that?
Yeah, I mean, I think it's kind of just a lot of reiterating again what was said before. But I think that it's really an apples and oranges viewpoint, and yeah, reiterating again, I think what Dina had said, and it's probably about it right now.
Maybe I would just add that for market definition, it's typically done by field of use. So that's how it's.
Yeah.
I'm not seeing any hands, so I'm going to throw a question towards Kyle then. So while others are thinking of a question. So Kyle, if you are advising your clients, let's say you're advising somebody who is a licensee, where would you advise them, or let's say if they were a licensor, first let's start with that. Where would you advise them to go, in which jurisdiction would you advise them to file? And then the same question, vice versa.
Well, this is easy because it depends on the circumstances. There are a number of factors at play when this kind of decision is being made. As I mentioned earlier, we don't have uniform law on the antitrust issues across the different circuits. And so if you're bringing a complaint, you better look at what the law is telling you in that circuit when it comes to the claim that you're going to pursue. You need to know that. The other massive difference, though, as everyone in the patent space knows, is the speed with which these sorts of disputes are resolved. And it can be the difference between 18 months and 5 years or more, depending on where you file. So a balance between the substance of the law in the area combined with the speed that you expect the court to proceed are key factors on the substance. You're still going to have all of the basic procedural questions you're always dealing with when you're trying to figure out where to file a complaint. You simply can't file in every single jurisdiction, so you've got to sort out the formal legal obligations. But once you know where you can file, you're basically going to look at which one has the law for you and how fast you need to move.
We've spent a lot of time this morning talking about how much faster other jurisdictions are, like the Unified Patent Court in Europe and China, and even, the UK courts compared to the US. So that's a big thing that we've been talking about since this morning. And I guess I'll ask you, Steve, are you seeing from your vantage point, are you seeing this kind of jurisdictional battles becoming more intense?
Yeah, absolutely. I mean, I think you're seeing, speed is certainly a very important thing. It's not the only import for patent owners in terms of selecting venues. It's also certainty in terms of what the outcome might be in those venues. It's also secondary challenges that might be available in those different venues. I think a number of years ago, obviously the viewpoint of how the PTAB was operating was a very different environment than today. So I definitely think, for example, rising on the list is U.S. It's always important, but I think it's become even more of an important consideration in view of those additional changes as well. But absolutely, I think it's there's tons of different implications that need to be considered. Timing is certainly one, but it's not the only one, and it may not be the number one. But But at the end of the day, with these fights, they seem to be global fights. And generally speaking, a singular action in a singular venue is not going to do it. I think that's probably the biggest takeaway.
And what's the most challenging thing for you right now for your business? What's keeping you up at night?
I mean, I think it's the uncertainty of the regulatory framework environment in the world around FRAND. I mean, I think every day I wake up wondering what news is going to hit from Europe, what news is going to hit from China, what news is going to hit from whatever jurisdiction, and what that implication is for our business in that coming day. And I think, you know, we have great people trying to monitor the winds, but it's hard, and those winds come from places that you may not even expect them to come from.
Maybe that raises me to say that that's why we do work hard to try and promote convergence, right, in these issues. Unfortunately, in antitrust, we don't have a WTO agreement on antitrust, right? So we can only rely on soft convergence, but we do make a lot of efforts to try and at least bring jurisdictions in closer. So I do hope that we will end up in the same regulatory place as, for example, actually with respect to the upcoming regulation, you know, there's talk about maybe the US and Europe might converge on LNGs, right? And I do hope that we will end up in the same place. I'm an optimist.
I mean, I was just going to say, Dina, that for things like this, we are seeing the exact opposite, right? I mean, we're seeing a diametrically opposite approach from the US and from the European Commission. So do you see there's hope for convergence?
Yeah. Well, I haven't seen any final documents, so let's see.
Okay, well, on that note, unless there are any other questions, I think we can take a very quick break and set the stage for Congresswoman Deb Ross. Thank you.